disclosure requirements of a group home depend on specific circumstances. Issue: is a real estate licensee representing a seller in the listing of the seller's residence required to disclose to a buyer the presence of a home care facility for troubled teenagers in the neighborhood? Answer: under the Federal Fair Housing Act, the Act, as amended in 1988, no person shall discriminate against a person with a disability or handicap in connection with the sale or rental of a dwelling. Under the Act, handicap means 1. A mental or physical impairment that substantially limits at least one major life activity, or 2. A record of such impairment, or 3. Being regarded as having such an impairment. See 42 U.S.C. paragraph 3602H. In this instance, the teenagers are described as troubled. Likely, a troubled teenager does not constitute a handicapped or disabled person under the Act. As such, the seller or the seller's agent would be required to disclose this home care facility. However, if the teenagers are found to suffer from a disability, the Act would prohibit the seller or the seller's agent from disclosing. These situations are fact-specific. A broker should consult with counsel about the specific situation before taking action. Fair housing law protects national origin. Facts: a real estate licensee wishes to represent the seller in the sale of his house. However, during the listing presentation, the seller states he does not want to sell his house to anyone that is not a United States citizen. Issue: can the licensee list the property for sale? Answer: probably not. Discussion: 42 U.S. Code, paragraph 3604 states it shall be unlawful: A. to refuse to negotiate for the sale of or otherwise deny a dwelling to any person because of national origin. The seller's request is a violation of the Fair Housing Act, and the licensee would be exposed to civil liability and sanctions against his license if he participates in the seller's request. The licensee should notify the seller that he is not interested in taking the listing, as it would violate the Fair Housing Act. Fair housing logo use during a transaction. Facts: the buyer and seller are under contract. The buyer's agent texts the seller's agent to inform her the home inspector will be at the property on Tuesday at 1 p.m. Seller's agent informs the buyer's agent that he must use the Fair Housing logo in all text messages. Issue: must an agent use the Fair Housing logo when texting another agent regarding a transaction? Answer: no. Discussion: the Fair Housing logo should be used when advertising real property or real estate services. The use of the logo is an indicator that the advertiser complies with the Fair Housing Act. According to HUD guidelines, paragraph 10930, Fair Housing Policy and Practices. A. Use of equal housing opportunity logotype, statement, or slogan. All advertising of residential real estate for sale, rent, or financing should contain an equal housing opportunity logotype. As a means of educating the home-seeking public that the property is available to all persons regardless of race, color, religion, sex, handicap, familial status, or national origin. The choice of logotype will depend, in space advertising, on the size of the advertisement. Here, the agent is not advertising real property or services. The text message is communication between two brokers regarding a real estate transaction. Accordingly, neither agent is required to use the logo, as they are not advertising a property nor their services. Fair housing poster must be in a language that reaches most of the population. Facts: a brokerage is in an area where a significant portion of the population speaks Spanish. The brokerage has a Fair Housing and Equal Opportunity FHEO poster displayed in the office, but the notice is only in English. Issue: should the brokerage also display the FEO poster in Spanish? Answer: yes. Discussion: Title VI of the Civil Rights Act of 1964 is the federal law that protects individuals from discrimination on the basis of their race, color, or national origin in programs that receive federal financial assistance. In certain situations, failure to ensure that persons who are limited English proficient, LEP, can effectively participate in or benefit from federally assisted programs, may violate Title VI prohibition against national origin discrimination. Therefore, because the brokerage is in an area where a significant portion of the population speaks Spanish, the brokerage should display the FEO poster in Spanish and in English. Fair housing protection of familial status. Not limited to tenants' children issue. The prospective tenant has completed a rental application for the apartment. The prospective tenant states in the rental application that his 12-year-old nephew will be living with him until his nephew completes middle school. There are no other children currently living in the apartment complex, and the landlord does not want to make an exception. Can the landlord refuse to rent the apartment to a tenant with a 12-year-old nephew? Answer: probably not. Under the fair housing laws, familial status extends to persons with legal custody of any child under the age of 18, or with written permission from the parent or legal custodian of a child under the age of 18. Therefore, the landlord can request from the prospective tenant written permission from the 12-year-old's parent or legal custodian. If the prospective tenant is unable to furnish such written permission, only then can the landlord refuse to rent the apartment to this prospective tenant. Sue note: anti-deficiency statutes protect homeowner from deficiency after foreclosure of home issue. After more than 20 years of mortgage payments, the homeowner paid off the mortgage loan on the home. The homeowner then borrowed $250,000 under a home equity line of credit, HELOC. Due to financial difficulties of the homeowner, the $250,000 HELOC has scheduled a foreclosure. If there is a foreclosure, will the homeowners be liable for a deficiency? Answer: no. If there is a foreclosure of any mortgage loan on a home, there can never be a deficiency claim against a homeowner because of the protection under the anti-deficiency statutes. This protection applies not only to owners of principal residences and to purchase money loans, but also to investors who own homes and to HELOCs and other non-purchase money loans. A home is defined under the anti-deficiency statutes as a single family or duplex on 2.5 acres or less and utilized as a dwelling. ARS, paragraph 33-814-G. Therefore, even though the $250,000 HELOC had not been used to purchase the home, there can be no deficiency claim against the homeowner after the foreclosure of the $250,000 HELOC. Note: inasmuch as the $250,000 HELOC was not used to purchase the home, the HELOC lender could have elected to sue on the $250,000 promissory note rather than foreclose on the deed of trust.